all of you joining us. Thank you very much. My name is Stephen Dodge. I am on the training subcommittee for Young AFSA, the young branch of AFSA, so to speak. Joining me for this evening's topic on the issue of Arbitration 101, we have got Mitchell Agatise. He is from Nigeria, and he is a senior associate and a team lead at Olaniwo Najayi LP's government business practice and a co-lead of the arbitration team. This practice spans high-stakes domestic and international arbitration, as well as complex and commercial advisory, reflecting a strong ability to bridge dispute resolution with strategic support across multiple sectors. Mitchell has extensive experience in complex financial and commercial matters. He was part of a team that negotiated for the restructuring of debts exceeding $400 million owed to multiple lenders, coordinated multi-jurisdictional legal strategies in high-stakes disputes, and have supervised foreign counsel in enforcement resistance proceedings. A very good evening to you, Mitchell. Thank you very much for joining us.
Good evening, and thank you for your kind words. Good evening, everyone.
Also joining us is Valerie Kawungu Chiyombwe. She is a Zambian lawyer and a fellow of the Chartered Institute of Arbitrators and has been practicing law for the past 15 years. Her practice areas include arbitration, mediation, construction adjudication, commercial agreements, procurement, to name a few, and she's previously served as a chairperson for the Young Members Group of the Chartered Institute of Arbitrators Zambia branch and as the convener of education and training. Valerie's practice as an arbitrator has involved ad hoc arbitrations in joint venture agreements, procurement and construction contracts and employment. She also specializes in advising clients on suitable arbitration clauses in various commercial agreements involving local and international parties. A very good evening to you, Valerie.
Thank you, Stephen. Hi, everyone. Thank you for joining.
And last but certainly not least, is a very good friend of mine, Advocate Khotso Washamane. He is a member of the Ireland Group based in Sandton in Johannesburg in South Africa. Having been admitted as an advocate on the 26th of February 2021, he has practiced from the Ireland Group chambers from that day forward and has a wide practice, including in the fields of administrative law, banking, commercial law, construction, insolvency, intellectual property, personal injury, and property law and restitution. A very good evening to you, Khotso, and thanks again for joining us.
Good evening, Stephen, and delegates. Thank you for having me, Stephen. Thank you for the invite.
Of course, of course. A little fun fact, Khotso and I have known each other for what must be nearly 15 years now, and we're both slaves to the lawyer trade, if you want to call it that. But in any event, let's get kick-started with our topic for this evening. As all of you would have seen, we are aiming this webinar at young and aspirant, brand new practitioners in the field of arbitration to describe exactly what the basics of arbitration are. You may have heard about a lot about arbitration, but you don't quite know what it's about. You may have heard about fallacies of arbitration, good and bad, and we're hoping that we can dispel some of those rumors and show you the light when it comes to arbitration as a very much mainstream form of dispute resolution. I don't even think we can even call it alternative dispute resolution anymore. It has become so mainstream that we are privileged enough to practice in this field. So let's kickstart with talking about where we are with high-profile arbitrations. You know, we know what arbitration is in a very general sense, but let's give you some numbers to try and baffle the brain a little bit. Arbitration doesn't just take place between countries or parties, I beg your pardon. It can take place between countries. Perhaps the biggest arbitration case in history with the biggest award is in the matter of Yukos Capital versus the Russian Federation. And that was an arbitration tribunal there that ruled that Russia had expropriated Yukos Oil's assets through a politically motivated campaign, and it ordered Russia to pay over $50 billion to former shareholders. The Russian government in this case had used fabricated tax assessments and rigged auctions to bankrupt Yukos, with the state-owned oil company Rosneft acquiring its assets. Now, that's an example of one of the bigger ones. That was a matter where the arbitration tribunal awarded costs in the region of 4.5 million euros. And that was quite a significant award and a big one in our history. Then we can talk about private matters as well, such as in the Crescent Petroleum versus the National Iranian Oil Company case, which arose from a gas supply contract where the NIOC failed to deliver gas, leading to an international arbitration award of over 2.4 billion US dollars to one of Crescent's subsidiaries. So that was another example of the numbers here. You can even go to the extent, we can just go through the list now of numbers which are a bit smaller as they go down the list. But as you can tell, arbitration is not only for the small guys, if I want to put it that way. It also involves the big guys. And that, I think, gives us a nice segue into what arbitration actually is. You know, we've all heard about it. So what really is it from a very, very basic perspective? And I think for this portion, I would like to hand over to Khotso, who will give us the basics of arbitration. You know, what, in a nutshell, let me start off with this sort of a question. We know arbitration is a form of so-called alternative dispute resolution. Although the fact is today it's no longer an alternative so much as it is a mainstream method of resolving disputes. But how does it set itself apart from the traditional ways of sorting out legal trouble?
Well, the first main benefit that most people who arbitrate are looking for is it to be expeditious. And your ability to choose your forum, your location, and your arbitrator. So one of the downsides of litigating within the High Court, more especially within specialized aspects of the law, is you don't get to pick your judge. Although judges have the resources to research all aspects of the law and the assistance of researchers for that purpose, if one wants a speedy resolution by someone who with experience within that field, arbitration usually is the way to go. So expedited proceedings are really the main benefit, but there can also be cost benefits. And if parties act ordinarily within the arbitration field and find ways to tailor-make their rules to whatever their dispute is, it can be a lot cheaper. You take away a lot of the issues relating to evidence and discovery, and the party can really define the dispute a lot sooner with access to an arbitrator who has the necessary experience. This also allows parties to consider whether they actually want someone who's legally trained versus someone with other training. So for instance, if the matter is really a question for an engineer and requires technical expertise, the parties could benefit from choosing an engineer over an SC or any other party with legal experience. And that's the true benefit. You can really tailor-make your issue and your dispute to something that provides you with the outcome that you desire.
Wonderful. And we're talking about it being not litigation in the traditional sense. The flexibility that we've got with traditional court matters means that, well, inflexibility with traditional court matters, if I may rephrase, means that, as you say, parties have got this ability to choose how their dispute plays out. They've got the ability to choose, I want to use the word, the right person as such to hear their disputes, the person with necessary expertise and the expediency, the one who's actually involved in the matter. Of course, one part of it is that the arbitrator does get paid for their services too. And that's, I understand, it usually shared between the parties. But on the note of it being speedier than court proceedings, is it possible that the opposite can happen? That you can actually find yourself bogged down in arbitration for whatever reason? And how does that happen?
It can occur in many ways. It actually can occur right at the beginning of the matter. So parties are entitled to choose their arbitrator. In terms of the Arbitration Act, if one party fails to do so or sends a request to arbitrate and provides potential arbitrators and the other party refuses, the matter then should go to court for the court to decide on who the arbitrator should be. That's already step one within the one step in the delay in arbitrating. Secondly, if the parties don't decide on the rules or the tribunal that should govern their dispute, it's going to be an issue there and defining how this matter will all be arbitrated. So really, it does come down to the parties themselves. But this is no different to ordinary court proceedings. A party that is going forward with an action may be delayed by discovery and all other type of dilatory tactics. So here parties are really, they can either help themselves and make this process as expeditious as possible, but they can also be the makers of their own doom, regrettably. And there have been judgments relating to this, particularly in relation to finding an arbitrator into whether the court should have jurisdiction rather. So for instance, if a party were to first bring their dispute to the High Court, and then the other party tries to interdict them from doing so and to have those proceedings stayed. Or the alternative where if one party brings a dispute for arbitration and the other says, well, no, this court shouldn't have jurisdiction because they are outside parties who aren't part of the arbitration agreement. So no, parties now have to bring stay applications within the High Court. So the court has to decide, should it go to arbitration or shouldn't it? And it's all those types of things that do sometimes hamper the expeditious consideration of the issue.
I think you've raised a very good point there about the fact that you've got parties outside of the arbitration agreement, outside of the contract and so on. And one of the key features of ordinary litigation, court-based litigation, is the fact that it's open to the public. That anybody can walk into a courtroom and examine, well, listen to what is happening there, listen to what could be fairly confidential information which is being shared with the judge and whoever is in the gallery at the time. So is that the main reason why parties value the confidential nature of arbitration compared to court proceedings?
It is one of the main attributes. I mean, there's a judgment indicating that as soon as the papers are before the court, they become public record. So while they're awaiting a hearing, it's not public record, but as the moment it's heard by a judge, anybody can sit there, anybody can get the pleadings and find out what was said. Now, if the issue between the parties relates to some topic that could cause reputational harm to one party or the other, or to both, that could be something that they both desire to leave out of the public sphere. For instance, partners within a firm trying to discuss how their money should be divvied up, or some other disputes that they may not want as part of the public record. Under those circumstances, it's best to just leave it outside. And this can be used as unfortunately, a way of forcing parties to settle sooner, or so on and so forth, just to avoid having the matter heard in open court and having that record be public. So if that is a concern for a company, any company at all, they should have arbitration agreements within them, because then the party can always try and stop the matter proceeding in the High Court and force the arbitration, subject to the court situation, of course.
Excellent. Now, we understand as well, you raised another very good point in the answer there, to the extent that we're talking about settlement. And one of the key components of any legal procedure is the fact that settlement's always waiting in the background. There's always that chance of it happening. And of course, we know about another form of alternative dispute resolution called mediation, where there is negotiations that go on, and you've got an independent third party who is trying to guide the parties towards their ideal resolution. It might not work for both of them in the ideal world, but it is going to spare them the expense and the time of going to court or going to arbitration. But how does mediation then differ from arbitration in the key respects?
So firstly, well, both have to be voluntary. Voluntary in that you have to, well, with arbitration, you agree beforehand. With mediation, you have to agree at the time. And arbitration is voluntary when you create the agreement. Mediation is throughout the process, because if one party is not there to mediate properly, there's never going to be a decision made, and that process is going to break apart. But with arbitration, the arbitrator can push the proceedings forward despite the delays of another party. They can make decisions within the process. The other big issue is that when one considers these aspects together, mediation assists arbitrations in one aspect. When parties mediate, oftentimes they don't really know what either party needs. So it can be a question of finding out what each party desires, and then there might be just one legal question that they require to be answered. And that could be a question that you then put before the arbitrator or put before an engineer, because then it's the factual or legal issue that needs to be decided, and then the parties to then mediate the rest of it. So the distinctions really are, can a party be held to the process? With mediation, you can't really force it, but with arbitration, parties can delay, but if there is an arbitration agreement, they're going to be forced to abide by it.
Right. Now, we know as well in the Johannesburg and Pretoria High Courts that mediation has pretty much been made compulsory before a matter can proceed to trial. And obviously, it means that there's an extra step that's in the process. And it means that there's going to be more cost, more time going through the traditional court process, of course, with a reasonable prospect of settling a matter. But for a matter which can't be arbitrated, then you have to go to court. But it may emerge from the mediation, at least, that the parties say, well, I'm going to refer this matter to arbitration if you would like to join me. Do you think with the fact that there's now compulsory mediation, we will see more disputes which would normally go through the court doors instead being dealt with through arbitration proceedings?
I do. I mean, consider ourselves. We are all mediators and arbitrators. So if someone were to come to us for a mediation, and you can see that the parties are close or still have some disputes that need to be decided, but they need it to be done expeditiously. When discussing the matter with the mediator can then advise them, well, listen, if you guys need a decision soon, or a party needs the money that is the subject of the dispute sooner rather than later, it may be beneficial to go the arbitration way. But beyond what us as arbitrators and mediators may advise the parties, I think by the courts advising mediation and the parties now being a part of that process, if the matter does get mediated, they've now dealt with mediators, they've dealt with arbitrators, their minds have been opened to the possibilities. And what I anticipate is your small to medium-sized companies will then see the benefit in including arbitration clauses in their agreements. So your first time burnt, you go to the High Court, you're forced to mediate. That's the subject that's the process you go through. But your second time you learn, and going forward, those small to medium-sized companies will start including those clauses.
I'm going to move over for an international perspective from Valerie and Mitchell. And Mitchell, I'd like to start with you in the sense that Nigeria has very recently updated its arbitration legislation, with the Arbitration and Mediation Act now having come in 2023. And I'll get to the Zambian perspective in a moment. But have you seen arbitration improving in popularity across the Nigerian legal landscape in the past few years, and how so?
Well, thank you, Stephen. And yes, indeed, we've actually seen it increasing in popularity. And there are three aspects, I would say, that have increased the increase in the popularity. The first is actually the Arbitration and Mediation Act of 2023. And the reason why is because one of the novel provisions that was introduced was a provision that more or less solidified the finality of arbitration awards and further limited the basis upon which it can be challenged to be set aside. Now, why that was critical was that the perception by business people and the like as it relates to arbitration, especially domestic arbitration in Nigeria in the past, was as though it was just step one in a long line of disputes. Because oftentimes after the award is obtained, counterparty will immediately file an application to set aside the award. And a number of times that application, even if it's unsuccessful, would at least be entertained by the court, which would create a form of delay. Now, with the provisions in the AMA, it seeks to basically limit that from happening. That's on the one hand. On the other hand is that Nigeria, there's a lot of extractives work going on in oil and gas, in mining, etc. And international counterparties or sophisticated counterparties in those industries, I think over time have become very at home with arbitration. And the reason why they've become very at home with arbitration is that With arbitration, it is the case that you're able to designate or identify who your arbitrator is, as well as the level of expertise that such an arbitrator would have. So as a result of that, those participants in those sectors would prefer someone who has real sectorial experience, and they are more likely to get that in arbitration than in court, because in court you may not know whether or not your judge even has a clue as to the type of agreement that is before him. And I think the third thing is that there's been a proliferation of arbitration centers in the country. So in Lagos, we have two, Lagos Court of Arbitration. Then there's LASIAC, is the International Arbitration Center. In Abuja, which is the capital of the country, there's one. Then, of course, the LCIA, the ICC, they do a lot of road shows into the country. So I would say that the combined efforts of all these local and international centers in seeking to push for awareness, sometimes about their own centers, but by implication, it's more awareness about arbitration and its benefits. And as a result of that, you would find many commercial agreements that the default position that lawyers would advocate for is arbitration. So that's what we're seeing in our market at the moment.
I'm going to pose the same question then to Valerie. Of course, Zambia's Arbitration Act is a little bit older from the year 2000, but Zambia also has the distinction of several large mines that are around there. I was involved in a mining project not very long ago. And we know that miners do tend to favor arbitration. Are you seeing an increase in matters being referred to arbitration in your jurisdiction?
Yes, indeed. Yes, indeed. And just like Nigeria, so many factors are pushing this popularity. So you start firstly, obviously, the Arbitration Act is 25 years old now, but in the last 12 years, we've had the Chartered Institute of Arbitrators, Zambia branch, pushing the arbitration agenda. And in the last, I would say, 5 years, we've seen an exponential growth in the training of arbitrators in the country, and most of these are young arbitrators who want to stand up and be counted. So they're standing up, doing so many big things, and this is trickling down really in the way they handle matters. Commercial agreements, you find that there are always arbitration clauses in them, embedded in them. And in addition, we have the Lusaka International Arbitration Center, which is a year plus old. So just that alone shows that arbitration has gained a lot of traction, and indeed even just agreements between just ordinary companies. We're finding that the arbitration agreements in there, even for a debt as low as $8,000, you find that there's an arbitration agreement, which really speaks to the nature of arbitration in Zambia, which has really gained its popularity. And then when you also look at the mining companies that you spoke to on, they're embedding these agreements even in employment contracts. You're interested to know, we had a recent case which was decided by the Court of Appeal where there was an arbitration clause in an employment contract. So that gained popularity. And then it also goes to show, like you earlier mentioned, to say in the drive to arbitration, it has its own special seat. So even when a party takes a case to court which has an arbitration agreement, those are quickly referred to arbitration. And even when a party applies to decide an award, the courts are now alive to the fact that arbitration is final. So it has its own place. And if there are no valid grounds set it aside, they will uphold the award and dismiss the application. So really in the last couple of years, we've seen arbitration grow in popularity for all these factors. Thank you, Stephen.
Wonderful, thank you, Valerie. I think it's interesting that we've got all of these various types of arbitration, and the matters, the areas where they can where arbitration proceedings can be used. So I mean, the concept of arbitration is so broad. It means that all these types of arbitrations have developed over the years. And I'm going to hand over to Mitchell now with the key question: what are those types of arbitrations? It's not unique to South Africa or to Nigeria or to Zambia. We've got universal forms of arbitration where they can apply. Of course, the laws in various countries will say, well, you can't arbitrate this kind of a dispute or that kind of a dispute. But generally speaking, from a commercial perspective, you are permitted to go to arbitration. So what types of arbitration are we likely to see across the world?
Thank you very much, Stephen. And you raise a valid point. So there are different types of arbitration that we see, both in practice and even, theoretically. So I think the straight vanilla one is just the commercial arbitration between two commercial counterparties. Now, in respect of that straight vanilla type of arbitration, there are two subtypes. So on the one hand is a commercial arbitration between two entities in the same jurisdiction. So a South African company, another South African company, both of them choosing South African law, right? So that's a domestic commercial arbitration. Now, you have another type of commercial arbitration, which is international commercial arbitration. And oftentimes that's a situation whereby the entities at play are from two different jurisdictions. So say there is a Zambian company as well as a Nigerian company, right? That's an international arbitration. Now, in respect of international arbitrations, beyond the fact that, look, it's two companies from two different countries, it's often also the case that you can have an investor-state dispute, okay? Now, with investor-state disputes, there are two types. There's a straightforward one whereby the state may have contracted either through an agency of the state, a state-owned oil company, for example, a state-owned mining company, for example. And in the contract, they had stipulated that dispute resolution will be by way of arbitration. And typically, the state would have waived its sovereign immunity, such as to enable it be dragged before an arbitral tribunal. That's on the one hand. But there's another type whereby it is the case that said investor has invested in a state. There is no contract directly with a state-owned entity. It may just be the case that they've obtained licenses from the state in order to be able to maybe mine a particular mining field. And in a period of time, the state has acted in a manner that has offended or otherwise affected the investment of this commercial entity. Now, those type of arbitrations have their life from something called a bilateral investment treaty. Now, those bilateral investment treaties oftentimes would have to be an agreement or a treaty, as the case may be, between the host state being the state where the investment is, as well as the home state being the state where that commercial entity is from. So let me give a quick example. There is a company called Steven Dodge Limited. Steven Dodge Limited is a German company. Steven Dodge Limited is a multi-million-dollar company and chooses to invest in South Africa. Now, it is the case that South African government says, look, we don't like Stephen who owns Steven Dodge Limited. So as a result of that, we're going to rob it of the license we had granted it. Typically, it will be the case, maybe a new government has come into place. If South Africa and Germany have a BIT, a bilateral investment treaty, Steven Dodge Limited would be able to sue the state of South Africa further to that bilateral investment treaty. And typically, there are strict grounds upon which you can sue. You can't just sue that, oh, I've lost money. It's typically on the grounds of maybe there was unfair and inequitable treatment, which is a public law standard that you'd find in many of these documents. It may be on the grounds of discrimination and some other grounds that are typically there under. So that's the type of arbitration you would tend to see. Then there are some other arbitrations that govern specific sectors. So sports, for example, when you have a sports dispute, it's often the case that you would go to arbitration under the CAS. Many South Africans on the call may be familiar with the CAS in light of Caster Semaya's cases, right? So it's the case that she couldn't have just taken the relevant body to court, it would be arbitration in that light. So that's what you tend to see in terms of the types of arbitration out there. Thank you.
So let's look at it then from a Nigerian perspective. You know, I think it would depend then on again on the legislative provisions that allow arbitrations to take place. But where are you seeing arbitration being used most in the Nigerian context?
Sure. Thank you. So mostly in the Nigerian context, we see it in commercial disputes, and we tend to see it more in financial services. We tend to see it more in construction. Construction, it's almost unusual to not see arbitration in a construction dispute, because even the underlying contracts, which are FIDIC-based contracts, typically would have in their templates arbitration as the default mechanism. As I said earlier, we see it a lot in extractives, oil and gas, mining, etc. Now, the statute, however, stipulates that there are some matters that are not arbitrable. Okay, so typically matters relating to tax, for example, taxation laws, matters relating to crime, for example, are not subject to arbitration. Then typically, and you'd find this in many jurisdictions, there would typically be an overarching provision saying that matters that are contrary to the public policy of the state are not arbitrable, right? Because you require the courts to handle such matters. So, for example, if the state considers a particular matter to offend, its natural conscience, etc., you'd find that such matters will not be able to be resolved by way of arbitration. And even though you proceed to arbitration because it's confidential, because it's private, you then have difficulty at the point of enforcement. Because if you then want to use the machinery of state to enforce, a competent lawyer on the other side will just look, hey, this offense, public policy is not arbitrable, and it should easily be certified. Thank you.
I'm going to come to a question to Khotso on that respect. You know, from a South African perspective, you and I both know that matters relating to the status of the person are generally not arbitrable. For example, divorces, you won't find those being referred to arbitration. But in South Africa, do you think that it's more or less aligned with Nigeria and where we see the most number of arbitrations taking place in particular industries or fields?
It is. So by number, I'd submit, or in my view, the labor industry is where you'd find most arbitrations within South Africa, by virtue of it being mandatory in terms of our law, where parties haven't governed otherwise. So the CCMA is an entity, a tribunal that is generally busy, and you'll find your other private entities have also started providing for arbitration within their agreements as well, to avoid having to air out their disputes with their employees publicly. So that is the situation there. But in terms of the civil sort of disputes, it's generally construction. Construction takes up the majority of arbitrations. They are dealt with the most frequently, and they are generally the biggest arbitrations within South Africa. There are other arbitrations within mining and other disputes, but those are really the two biggest in terms of frequency and in terms of amount.
And I suppose we're seeing as well in much across the continent, the fact that Africa is a developing continent and in some parts more developed than others. We're seeing it from the South African context that infrastructure development is significant. And then this is where I've got a question for Valerie. Zambia has also got a big infrastructure drive that is on the go. Are you seeing arbitrations being used in respect of infrastructure projects, construction projects as well?
Yes, indeed, a lot actually. But interesting enough, construction adjudication was used the most in the recent past. But now you will find that an arbitration clause will stand out more because of the nature of construction adjudication. There is that tiered dispute resolution mechanism. So now, with the recognition that arbitration is a quicker process, quicker than the two-tiered process under construction adjudication. So we're seeing more and more this being used in resolving construction disputes in Zambia, and more construction practitioners being trained to, represent clients effectively as they are undergoing an arbitration involving a construction dispute. Thank you.
I see. Well, Valerie, I'm going to ask you to help us out with the next topic, because I think this is where I want some of your expertise, in the sense that let's go back a couple of steps. Now we've got our arbitration. We know what arbitration is. We know that parties want to deal with their dispute through arbitration, and we know what types of arbitration there are. But what is the real genesis of an arbitration?
Agreement. That's where the jurisdiction of an arbitrator lies. So the parties have to agree to arbitrate. So agreement or agreeing to arbitrate is not a typical yes who agree to arbitrate. Sometimes it is inferred from the communication between the parties. So for example, if party A says, look, can we refer this part of the dispute to arbitration? Maybe they could have had the contract running for some time, and maybe a dispute arose in part of the transaction, and we were able to resolve it through negotiation. And later on, a dispute arises, and one of the parties suggests to refer it to arbitration, and the other says, maybe reluctantly or not, that, okay, fine, what are you thinking? What kind of qualifications do you think this arbitrator should have? That will be interpreted as an agreement to arbitrate. In addition, when parties decide to submit themselves to a certain law, so for example, in Zambia, procurement laws have an arbitration clause embedded in the Procurement Amendment Act of 2023. So if a bidder is unhappy with the decision of the authority, they are duty bound to refer the matter to arbitration. If they go to court, that matter will be stayed and referred to arbitration. So there's also the statutory agreement where you are forced, or you're inferred to have submitted yourself to arbitration. But then also, when you look outside, there's the issue of where you draft your arbitration clause in line with ANIAN's rules. So for example, you could choose to submit your dispute to the ICC, to the Kigali International Arbitration Center, to Lagos, to wherever you feel that you'll be happy with, and you feel that the arbitrators possess the certain qualifications that you require. So really, it's about that initial agreement, either embedding the clause in your contract, or eventually through correspondence you agree, or through you submitting to the rules of an entity that runs arbitration, then you would have agreed to arbitrate. And like you said earlier, once you submit yourself to arbitration, you cannot get away from it. So even if you refuse to move actively along, somehow, somewhere, the award will be rendered by an arbitrator in the face of one of the parties being active.
I must interject at this stage to inform our wonderful audience. Please do use the chat function. If you have questions for any of our panelists this evening, please do use the chat function to put your questions in, and we will get to them at the end of the session. So at any point, if something does pop into your head, please pop it straight into the Q&A. Valerie, you were talking about the fact that you've got situations where you have to go to arbitration under the Zambian law, for example. But of course, one of the more sort of finer nuances of arbitration is disputes related to procedural matters. How can you deal with those? And often these are situations that the parties would not have thought about from the very beginning. They've got an arbitration agreement which says, well, if this happens, we go to arbitration. If that happens, we go to arbitration. But if they did not cater for every possibility, sometimes those procedural disputes will land up in court. Do you find, at least that is in the South African context, do you find that something similar occurs in Zambia and across your practice? Or are parties generally more willing to sort of get on with the process instead of becoming bogged down in court-related matters, just to deal with how the arbitration will work?
Yes, indeed. And one of the most common ones we find is where the parties had agreed, but maybe they didn't even understand what they were agreeing to. They were going to refer the matter to arbitration. Now it comes to a point of appointing an arbitrator, and the clause in arbitration with the arbitration agreement was not very properly drawn, but it's valid. So, for example, if they didn't mention what entity is going to appoint the arbitrator, they get that stuck from the beginning. They don't know what to do, and there's a lot of hesitation. Other times, you find that one of the parties is quite proactive and they suggest names of arbitrators. The other party will cancel everybody on the list and say, no, I'm not happy with these the choices that you've made. So you will find that the parties are engaged in a bit of back and forth before the process could actually begin of trying to agree on the appointment of an arbitrator. And sometimes they don't even know which institution to approach to appoint an arbitrator because the agreement was generally drafted and they're stuck. They're just stuck. So you find that they have this a little bit back and forth, and those who are not really knowledgeable about the process of arbitration and how it relates to litigation, they'll end up in court, and the matter will be thrown out, or the proceedings will be stayed, and they're referred back to arbitration. So they'll go through this cycle of trying to appoint an arbitrator and trying to go to court, and before you know it, they would have lost a bit of time in trying to, run away from arbitration. So that's one of the commonest procedural issues that you'll find. Stephen, you're still muted.
I beg your pardon. Thank you. I suppose that then feeds into the point of why arbitration agreements, it's so important that they are solid, that they contain all the detail necessary for the arbitration to run. I mean, it's then difficult for parties to come after the fact and now try and get out of that arbitration agreement. It is, after all, a contract. But why is it so important that the parties give the real fine details of how they want the arbitration to go along? So, for example, the seat of an arbitration. Let's say it's going to we've got an arbitration that's going to take place between a South African company and a Zambian company, and the seat of that arbitration is going to be in Lusaka. Why is it important for arbitration agreements to contain as fine a detail as that?
It's very key because the seat speaks to the procedural rules that will apply to arbitration, and so you need to know, especially in international arbitrations, that this is a country which is party to the New York Convention and that it is arbitration friendly, so to speak. So it's very, very important because the nature of arbitration requires that the seat that you choose is friendly and understands how to interpret arbitration, looking outwards in terms of the international application of the laws that govern arbitration in general. So it's very, very key for parties, even for arbitration advocates, even those who are coming, like our audience today, to ensure that they go online and go to the institutions that they've heard of. So, for example, you have AFSA, you have Kigali, and many others. Even the Lusaka International Arbitration Center, they have standard arbitration clauses, even the ICC, because it's very, very important that if you're choosing a jurisdiction, you know that this jurisdiction is going to be your seat in terms of the procedural rules that will apply. It's very, very key, and you'll find that some parties have had challenges to move forward in arbitration because then they realize, because at times, most times, that's why they call them midnight clauses, you're drafting an arbitration agreement, because now you are pretty much done with your agreement, with your commercial agreement, and now you just to seal it all together with an arbitration clause, and you have not really thought through things because you're thinking, since we're tossing champagne, everything will be hunky-dory. But when that time comes, when a dispute arises, and you realize that the seat that we actually chose could be friendly to the other party and not us, because there are all these beliefs that if a country appears to be friendly to the other party, then they'll be more favored. So that's why even for example, I came across one of my colleagues' argument where they're saying that if your an investor, for example, is coming from Zambia, please do not pick Zambia as the seat, because then it will show that, you know, you're trying to get your courts to favor or to even frustrate the process in case you have to approach it for procedural orders. So, I mean, so these are some of the nuances you have to deal with as you're drafting your arbitration clause, and you need to ensure you address all these issues with the other parties, so that even as you go forward, you don't find or meet unnecessary changes that might delay your process. Thank you.
Well, I think that's an interesting point that you raised, the fact that, you know, it may turn out that one party is upset with how the arbitration has turned out for any particular reason. It could be, you know, what they perceive to be an unfriendly arbitrator or an unfriendly jurisdiction or something. So then the matter of an appeal comes into the picture. And looking at the fact that it is simply up to the parties to decide if they want to take an arbitration award on appeal, they must then include that option in their arbitration agreement. Do we find, however, that arbitration appeals are rarer in international arbitrations compared to domestic ones?
In Zambia, we have the setting aside procedure. But for international arbitration, the statistics are not available. I've not come across any. I'll still look. But in Zambia, we have the setting aside procedure. We don't have the appeal procedure. So I know, because a party is not just happy with how the arbitration turned out, and, you know, they want to sort of appeal against that decision using the process of setting aside. So you find these are very common, and the common ground that is used is it's against public policy. So you find that you know, the parties end up going to court, but we have no provision for appealing against an arbitral award, because in Zambia jurisdiction, there's finality. Once the arbitrator renders that award, then is functus officio, and the parties are expected to abide by the arbitration award unless they want to set it for reasons that are outlined in our law.
Khotso, I'm going to move on to you with a question in respect of free will, in the sense that we've got a contract. Generally speaking, contracts will reflect the intention, the parties' intentions, and courts are hesitant to interfere with that from a contractual perspective. But are there examples, and Valerie raised a good point earlier in respect of public policy, are there examples of a court finding it necessary to interfere with the parties' free will when it comes to the arbitration agreement?
There are. So we mentioned one such instance where there may be parties who aren't a party to the arbitration agreement itself. So those parties may consent to the jurisdiction of the arbitration and agree to it. That's something that can take place after the fact, but they're not forced to do so or bound to do so. So the courts, when faced with that sort of situation, will generally find against the parties going to arbitration, just because, or the main reason is to avoid a multiplicity of actions and different fora coming to different conclusions of either law or fact. One might think, for instance, if in the arbitration, one party is found guilty for having liable for not properly conducting themselves and not doing what they're required to do. And then when it goes to the high court and the subcontractors are sued, the high court finds that, no, they did do the work properly. So that would be a dispute that just would be untenable to the parties. But secondly, there's a judgment of Northeast Finance versus Standard Bank of South Africa. So what that judgment, it's an SCA judgment, what that judgment eventually found is that really what's at issue is, what were the parties contemplating when they concluded the agreement? So arbitration agreements and agreements in whole can, within the arbitration clause, identify certain aspects that would be arbitrable. So issues regarding liability, they could say are arbitrable, or issues regarding what actually took place. So for instance, if it's going to be a question of how is this matter to be fixed, or who is liable for the engineering failures, that might be something that you send to arbitration, but leave the quantum itself for the court to decide. The parties can split it however they may, but the court will generally try to find what was in the contemplation of the parties. But what took place in the specific SCA case is the parties concluded a settlement agreement. Within that settlement agreement, they added an arbitration clause. And once the one party tried to enforce it, the other party then realized, oh, well, we were defrauded here. We were told one thing, and that was the reason why we entered into the settlement agreement. And by virtue of the fraud, this agreement or settlement agreement was void ab initio. So ordinarily in arbitration, the arbitrator should consider his own jurisdiction. So if one party says, no, this contract is invalid, that is something the arbitrator can find. But where it really strikes to the agreement itself, so misrepresentations, frauds, and so on, the parties cannot hold on to that arbitration clause because the entire agreement falls away. But it can be a question for the arbitrator if it's just a question of, does the clause itself, or put differently, have the parties contemplated that the specific dispute will be one that will be arbitrated? That's something the arbitrator will generally consider.
Fantastic. So we've got our arbitration agreements. We've got, say, we have a matter that is capable of being arbitrated. The parties have agreed that they want to go to arbitration, and now we need to talk about it in practice. And the very first step, I suppose, is for there to be a dispute. For there to be something of being capable of being arbitrated. It must obviously take quite some time, one would think, to get from the initial stages of a disagreement between the parties to the point where a full-blown arbitration is required. Or is it more complicated than that? Should this idea of we are now ready to go to arbitration, should that instead be considered on a case-by-case basis, or is it right, dispute, off to arbitration we go straight away?
So this is an issue that should generally be considered on a case-by-case basis. There have been disputes regarding, or rather what step one is there a dispute? The courts find that if there isn't a dispute between the parties, you can't go to arbitration. You can't send out a statement of claim or go to the necessary society. And what a dispute entails is there must be some issue between the parties where they aren't in agreement. So for instance, if I'm wanting money from a company because I did work for them and they haven't paid me, if I make the demand today and they haven't paid me, I can't just go out and institute an arbitration. There's no dispute as yet. I haven't given them the opportunity to pay, and one should, unless it's contracted, it should be a reasonable time. But if, for instance, the contract says 30 days, I can't go for arbitration on day 31. There must be some indication that they dispute the amount or liability at all, or you leave a sufficient amount of time before you start your arbitration. And that's what the courts have found as a proper dispute that is capable of arbitration.
So we have our dispute, and now we need to decide, okay, we're going to, what rules are we going to use? How are we going to deal with the real practical steps? We do this step, that step, as you said, statement of claim, then a statement of defense and a reply, and so on. And it seems that there will be relevant laws and rules that will confirm how it is started, usually by a request that is sent by one party to the other or to an arbitral institution, such as AFSA in South Africa, the Lagos Court of Arbitration, or the Nigerian Institute of Chartered Arbitrators, or the Lusaka International Arbitration Center in Valerie's country. But exactly what function, on a practical level, what function do these administrative bodies actually do? Why are they here?
They assist parties in ensuring that the arbitration continues and follows the correct procedures. So, for instance, when one starts the arbitration, you approach the institution, and the institution will first identify whether you have agreed to arbitrate, and then they'll start with your statement of claims, ensure that all your documents are ready for you to start your arbitration. Then it's a question of picking the arbitrators once the other side come in and dispute, or if there's no dispute, an arbitrator will still decide your dispute, but it'll go ahead unopposed. But they will help the parties throughout the process, and they ensure that any minor disputes are dealt with expeditiously. What comes when parties don't identify an institution is what falls into an ad hoc arbitration, where now the parties aren't sure and will have to argue about what rules are going to apply and how certain disputes are going to be dealt with. Now, that's something that, because AFSA and other institutions will have those deadlock mechanisms, those are issues that will be dealt with sooner and more expeditiously than not. So identifying the institution that will be governing the matter is something that I advise every party that's considering arbitration to do within the agreement. If not just the rules, at least the institution itself, because the rules may also provide the parties the necessary help and safety of not having to go into and dealing with multiple smaller disputes and delay the process more than it needs to.
So then we need rules as well about for example, the appointment of tribunals. It was raised earlier that there can be difficulty sometimes when you want one arbitrator as party A, party B comes along and says they want a different arbitrator, and now we're at a deadlock. We don't know what arbitrator we want to choose for purposes of our tribunal. If there's maybe 3 arbitrators, we haven't got an agreement here. Do the rules that are published by the administrative bodies, do they take into account these sort of situations?
They do. So the parties, if they've identified the sort of expertise that they want the arbitrators to hold, the institutions may have people within their ranks who are arbitrators who can assist in that. So they will then advise, okay, here's a list of 10, and if the parties themselves can't decide, they will allocate an arbitrator. So that avoids that instance. What can also take place is a dispute regarding the necessary expertise. Do we want an accountant, an engineer, a lawyer? Where's the main dispute? And that's something else that the parties can approach the courts if necessary, or if the institution itself provides, they can approach them and the institution will advise on which arbitrator should be picked, considering all the necessities and the expertise required to finalize the dispute. Just on that, there is a case specifically dealing with when there are different expertise required. It's the arbitration, it's the Pinta Africa Construction versus P2 Ltd versus Cape Provincial Administration. I think it's 1970s case. So these disputes have been going on for quite some time within our courts.
I'm going to move on to you, Mitchell, and I think this might be a question which you're fairly au fait with. We've got rules there for a reason. We've got administrative bodies that are there for a reason, to help us out, as we've heard from Kotso now. Have you seen personally arbitrations that proceed without there being an administrative body involved in Nigeria? How often is that the case? Is it just a situation where the parties decide, well, I'm not going to involve the Lagos Center or the Lagos Court, I beg your pardon. I'm not going to involve anybody. We're just going to sort it out amongst ourselves. Is that a reality there, and how often does it happen?
Yes, it is a reality. And I've actually been involved with one of such. So those arbitrations are known as ad hoc arbitrations, generally speaking. Now, personally, I don't like them because a number of times they're not as precise, especially when there are complex issues that arise. Okay. Now, 2 things happen. Number one, in the case I was involved in, most of the ones I've been involved in have actually been institutional. But the one I was involved in, we were lucky that we had a very senior arbitrator as the arbitrator for that dispute. And it was also the case that the parties, there wasn't much difficulty in terms of the initial stages. After we sent our notice of arbitration, they were compliant. Now, what happened in that matter was that ahead of every hearing, we would receive a procedural order by the arbitrator. So basically creating or otherwise putting together the rules to govern certain aspects. Also, every time we had to make an application on something that otherwise should have been dealt with by institutional rules, she would rule on that application. And these applications were even as minimal as things such as who files their final address first. Are we going to have final addresses after the taking of evidence? How is evidence going to be taken? Is it going to be the case that all witnesses can be in? So as minor as those matters, which ordinarily would have been dealt with in the institutional rules. So as I mentioned, we were lucky that we were dealing with an experienced arbitrator. Now, it's also the case that the Arbitration Act in Nigeria also has its own rules, actually. So there's a provision that stipulates that where parties do not disclose rules and don't agree, right, those rules would then apply by default, okay? So it also ensures that you're not in a lawless state, right, because you're doing arbitration or because the drafters of the agreement fail to avert their mind to it. And that could be very useful in an instance where the parties are at significant loggerheads and cannot agree to anything, including how the arbitration will be run. But as I mentioned, my preference is always to have an institution as well as institutional rules. And here's why. I was involved in a very recent matter. This was LCIA, okay, London Court of International Arbitration. And in that matter, what had happened was that the counterparty was basically recalcitrant, did not respond to our notice of arbitration, nothing. So because we had the instrumentality of an institution, right, when we were unable to agree on who our arbitrator will be, the LCIA, pursuant to their rules, were able to so appoint. Then we also needed a preservatory order, even prior to the fact of the constitution of the arbitration panel. And there are provisions in the LCIA rules that basically allow you to apply for an emergency arbitrator just to handle that matter very quickly, even though he or she will not be the arbitrator for the process. And those are things I don't know how would have achieved if it was not an institutional arbitration. Thank you.
So if we're looking at it, then that we've got the rules that regulate the process, and those are typically hard and fast rules. It's difficult to change them. Mm-hmm. Is it possible? Can the parties amend the rules if they need to, and is it a good idea?
Yeah, the parties can agree as to what will apply and what will not apply. And this goes to, I believe it was Valerie who had mentioned the point earlier, that the bedrock is agreement, right, in arbitration. So parties may, in fact, say that, look, it shall only apply to the extent of XYZ, right? It should not apply as it relates to provisions on, I don't know, emergency arbitrators, for example. So parties are able to do so. And if it has been stipulated in the contract or as an agreement outside of the contract, but in writing, then ideally the arbitrator or the arbitration panel should honor that. Now, whether or not it's a good idea is a different ball game. I would imagine that for parties to have agreed to something of that nature, they must be very sophisticated parties and with sophisticated counsel, because it would be very difficult for parties who are not sophisticated to persuade the other as to why they shouldn't have any of such provisions that have been well baked for such a time as that. Okay, now I also just want to throw this in very quickly, that you could even have a situation where you don't have an institutional arbitration, it's ad hoc, but your agreement then says, however, the rules that will apply will be, for example, the LCIA rules. So even though the LCIA is not the administering body, but the rules are what the arbitrator or arbitrators, as the case may be, will have recourse to for the purpose of overseeing that arbitration.
So this is an interesting point that we raised when we were initially discussing the planning for this webinar, and you raised it very succinctly, and I think it feeds in quite nicely to what you just explained to us. Where the parties can amend the rules if they need to, but they need to be sophisticated enough to do so. With the advent of AI coming into the legal sphere now, as much as it is, do you foresee a need that AI be regulated by the rules that are published by these bodies? For example, the ICC rules, or as you said, the LCIA rules.
Yeah, I honestly think that if they are not already thinking of doing it, they should be. And the reason why is that AI is, I mean, in several respects. On the one hand, as it relates to counsel, the work of counsel, you would have instances, we've seen it in court, and we're increasingly seeing it in arbitration, where hallucination arrived cases are finding their way into pleadings and or document processes, etc. And there has to be clarity as to what happens in those instances. That's number one. Number two is that apart from counsel, I suspect that the registries of those institutions may also have persons who are deploying AI that may not be the institution sanctioned AI solution, in which case there could be issues. You had, for example, Stephen, or no, it wasn't Stephen. I think it was Kotso that had mentioned earlier that there might be instances where the institution would actually provide you a list of potential arbitrators. Well, imagine that's AI and you can't find three of those names, and you're like, well, guys, for the past 1 week, we've been trying to contact this individual, and we realized that it was an AI generated name, for example. Or it is the case that an AI tool says that there is no conflict as it relates to XYZ arbitrators, but indeed there is conflict. Okay, so that's another angle that needs to be dealt with that may not be external facing rules, but are then internal facing rules as it relates to the machinery of that particular institution. Now, on the third angle, and which is very interesting, is as it relates to the arbitrators themselves. The arbitrators are provided with significant material that they have to read through, especially if the arbitration is document heavy. And surely there must be that temptation to just, dump it in AI and say, give me a one-page summary of who's right and who's wrong. Now, what happens in that instance? Does that become an instance by which you can then apply for it to be set aside? Are there, should I say, areas where you could be more comfortable in the arbitrators utilizing AI maybe to give the summary of the facts as against replacing their eventual judgment? And there's the final point about the push, right? For many to say, well, AI itself can be a bot to adjudicate the dispute. Question, should the institutions begin to look into that? Should they begin to potentially say that, oh, by the way, we have a service whereby under the LCIA auspices, we have our own AI that can adjudicate your dispute. It won't take you 6 months. You do it in the day. Everybody submits, and within that 2 hours deep think, you get your results. Is that something that could be pushed? And if it's pushed, questions then arise, will it be contrary to public policy at the point of enforcement? So there's a lot, I think, to unpack. It's an area that is moving at such blistering speed that you can't really place your finger on what should be done. But what I would say is that, especially for the young lawyers here, it's an area to continue to think about, write about, research about. Who knows, maybe someone's article may be the framework that will be adopted by many of the leading institutions as to how they would regulate that area.
Well, I think you've raised an excellent point there in the sense of the fact that AI is evolving so fast. And what I'm hearing is that I think the Young AFSA Training Subcommittee needs to organize a webinar on the impact of AI in arbitration. I think that is a very good idea. So thank you very much for that. Valerie, I'm gonna swap over to you now to ask you in a nutshell where we are with Zambia's arbitration law, because we know that Nigeria has got the 2023 Arbitration and Mediation Act. Zambia, of course, we touched on it earlier, has the 2000 Zambian Arbitration Act. And the fact that Nigeria updated its legislation after only 9 years, and Zambia's law is 25 years old. Do you see, in the sense as well of what Mitchell was saying in respect of AI, do you see a need for the Zambian Act to be updated anytime soon?
Yes, Stephen. Actually, we're in the process of amending or updating the Arbitration Act. And, since the Act is modeled after the model law, and because it's domesticated it, and it is in the first schedule to the Act, even the model law has been updated with I think that was the 2006 amendments. But even then, since the updating of the model law, so many developments have taken place, especially since the onset of COVID. The developments relating to the use of technology. There are also developments that have come now relating to third-party funding. So these are some of the conversations that need to be included in terms of having an arbitration act that is updated to respond to the times. 25 years is a long time to not update legislation. So many things, even in practice, so many things that we come across, even when we attend international conferences, so many things are coming up. And also the practice now is to have an act that merges either one or two other forms of ADR. So you find some acts have got an Arbitration and Mediation Act, others have got Arbitration, Construction and Mediation Act, others have got Arbitration and Reconciliation Act or something in those lines. So really the movement is to have an act that is all encompassing. It speaks to other areas of dispute resolution, such that when even an outsider comes in and they want to know what law you have, you don't have to start scrambling around speaking this legislation and that legislation, but you have one piece of legislation that speaks to what they want to achieve. And then also, like earlier when we spoke about the seat of arbitration, that's the procedural law that you've picked on. So you have a colleague coming in from South Africa, and they want to use the procedural law in Zambia to apply to court to enforce, and they need just some guidance from there. They would want to be scrambling around, and I think the practice is just the way arbitration works. To be efficient, even just in practice, it needs to be efficient. The law needs to speak to something that can be codified, looking at what others are doing, because arbitration, unlike litigation, has to be unified. The rules don't have to vary so much. So even in terms of some of the best practice, I think that this is the right time to amend the act. We did have a launch at the Lusaka Arbitration Week this year of a zero draft, but there's a bit of work that needs to be done. But I'm so sure that in the next year or two, we should have an act that is updated. Thank you, Stephen.
Well, thank you for the folks that are listening. The model law that we've been referring to is more fully known as the UNCITRAL model law. And what does UNCITRAL mean? Well, that's the United Nations Commission on International Trade Law. It's the model law on international commercial arbitration. Now, Valerie, I'm gonna ask you to go on a bit further about this in the sense of conflicts between the model law and the Zambian legislation, where one simply doesn't fit the other. In the South African context, the model law came along, and then thereafter came the International Arbitration Act, I beg your pardon, and that was in 2017. So the South African legislators obviously saw a need for that to be codified, to be brought into our law in a formal manner. And now we've got a second piece of legislation that we can rely on when it comes to international arbitrations. From a Zambian perspective, are there situations where the current law and the model law simply do not talk to each other?
Fortunately, oh yes, I'm on also. I thought I was muted. Yes, so fortunately we haven't had incidences where there's been that kind of a conflict, and maybe also because we had an old act before the current act. So we had that act repealed and replaced with this act, which literally domesticated the model law. There are very minor modifications from the model law, very, very minor in the coverage, what areas the act applies to. It's very, very minor. It applies obviously to arbitrations, domestic, and those which the government is part of. It restricts sort of, it reduces the coverage, but it's efficient in the way it is applied. So we haven't had any conflict, and well, maybe they've been, the nature of arbitration is private and confidential unless it goes to court. But from the reported cases, we haven't had conflicts that have been reported. Obviously, like I said, the most common issues that have arisen have been to do with setting aside an award on grounds of public policy, even in some of the agreements involving businesses and entities, local entities, and also just employment contracts of locals who are working for the multinationals in the mines, have always been public policy as the grounds that have been advanced to set aside the award. But we haven't had any reported issues to do with conflict of the model law and the local law. Thank you.
Thank you. I think you provided me with a very useful segue. I'm going to ask Kotso to deal with the next question. Valerie was mentioning the fact that there are situations where the court does need to step in, and we discussed this a bit earlier this evening in the sense of where there might be procedural disputes between the parties. But that said, that's not the only part where a court needs to become involved. It also is a possibility that you get an arbitration award, which is final generally and binding under the rules combined with the legislative provisions. But sometimes a party that's now had this award simply won't stick to it. What can the South African courts do to help that situation?
Well, our Arbitration Act provides for a party to approach the court to have it the award made in order of court. And that allows the party to enforce it in terms of our ordinary legal rules, issue a writ or take whatever steps that may be necessary. I mean, if it's for specific performance, do whatever steps are required there. So the parties are protected by the provisions of the Arbitration Act, ensuring that the award itself becomes enforceable. As an award, the party should generally follow it, but it just creates it happens often, but it creates extra costs when one party doesn't. But you do have recourse to the courts.
So if we take it a few steps back, let's say that not only is this party now challenging the award, they're saying, well, the agreement to arbitrate simply wasn't effective in the very first place. We never agreed to arbitrate. We don't think that we should be subjected to this process. Now we're right at the very end of it. How would a court deal with that kind of a situation? How would the other party deal with that kind of a situation?
So generally the courts will look at if the agreement itself is enforceable or the parties agreed, as I stated earlier. But the courts do look at when was this issue raised. So if a party raises the issue of lack of jurisdiction rather early, the courts are more willing to listen. But generally their view is if this issue can be decided on review, and that's a decision that can be considered on review, then let the parties finish out their arbitration and then the courts will step in. But if it's done at the beginning, the courts are more willing to consider those procedural issues that may arise between the parties.
I'm going to move on to the final topic. Thank you very much, Kotso. The final subtopic for this evening, we're going to be talking about a couple of slightly more controversial aspects of arbitration. And I'm very conscious of the time that we've got left for this session. So, Kotso, I'm going to start with you. In a minute, what is the future of arbitration in South Africa?
I think it's everything. To be honest, as more legal practitioners become arbitrators and mediators, we are going to have the skills that allow us to adjudicate better. I think arbitrators will then become our future judges, and the process will feed into the courts as well. So the arbitration will assist high court litigation and Secondly, arbitration will take some of the weight off of the high courts because they won't have to deal with as many disputes. As some of us would know, our high courts are sitting at a point where actions or trials are being set down 3 to 4 years out. So that is a situation that no party should have to live with, and arbitration is going to be a huge assistance.
Thank you. Valerie, you're up next. We know we've been talking about all the lovely good things about arbitration this evening, about why it's a good idea, and why it provides such a viable alternative. And I don't like using that word alternative. I think it is more mainstream these days. But let's look at, in a minute, what are the criticisms of arbitration?
The criticisms of arbitration, I think, where you weigh cheap versus expensive. What do they really mean by cheap? So you will find that when you compare to litigation, you interpret it in terms of the cost and the time that is spent on litigation as compared to arbitration. But in the long run, if you faced with an arbitration that is technical, it might take long and it might be more expensive looking at it. So sometimes it is weighed in that regard to say that it's even more expensive because it's a mini trial or it's a mini litigation. So everything else should be should differ, in terms of how much is spent. And then also the issue of lack of precedence. Some of the criticisms have been that, yes, for arbitration to grow, we need to see what's happening. We need to follow certain rules, or at least we need to understand why certain things turn out the way they do. Even for young practitioners, that's a complaint to say, look, we don't have these precedents. So the move really now is to try and see, I think even internationally, where you can redact some portions of an award or summarize it and just distribute it so that the young practitioners, or even those who want to learn from certain technical aspects of an arbitration on how it was handled, maybe it involves a complex mining contract or a complex energy contract, then you'll be able to learn if it's redacted or summarized or made different. So when you look at judgments from the courts, they're readily available almost immediately after it is rendered. But for arbitration, if there's no appeal, there's that private aspect where it's private and confidential, and it only stays between the parties and the arbitrator unless there's an application to set award. So these are some of the, under a minute, hopefully, the criticisms that we've received. Thank you.
Mitchell, my final question before we get to audience questions is going to be for you. Now we've heard from Valerie. I'm going to put the opposing version over to you. Why should disputing parties use arbitration more often?
Well, thank you. I think I get the easy end of Valerie's stick. So ideally, I think number one is that you have the opportunity to ensure that you're before a panel that understands the technicality of the issues before you. Number two, you're able to ensure that you're having speed, which in some jurisdictions on the continent is not something we can always guarantee. I think the third issue is also the fact that, strict rules on evidence and the like that sometimes prevent one from, getting to the heart of issues as flexibly as one would be able to, may be waived, right, in such arbitration, such that there can potentially be a wider exposition of the matters before one. And I think finally is the point on privacy, right? Especially when, certain companies don't want to air their dirty linen in public, because sometimes even just the fact of litigation or the issues arising from that public litigation can affect things such as stock prices, confidence of consumers in the business, etc., which may not be as conducive for a company. So privacy is a very big deal. And I think finally, the internationality of it, when you have international disputes, and the fact that further to the New York Convention, you could potentially enforce around the world without having to think on general rules on recognition and enforceability that may sometimes hamper or otherwise hamstring litigation judgments elsewhere. So that for me are the key reasons why.
Wonderful. Thank you very, very much. I'm going to move on to some selection of the questions that we've received in the Q&A, and a very big thank you to our audience for sending these questions through. I'm going to try and move through them as quickly as I can, so that we have enough time to get through to all of them. Khotso, I'm going to ask you to start out with this first question. From an anonymous attendee, what are some of the strategies to overcome a party frustrating the conclusion of an arbitration agreement? So it's a bit of a nuanced question, this one.
The conclusion of the arbitration agreement itself. I think that just requires a party to understand what the general disputes are going to be beforehand. Oftentimes, and the reason why arbitration clauses aren't generally at present included in agreements is parties think, oh, this union will last forever and nothing will come of it. But a party needs to understand, look, if you at some point want to sue us for money outstanding, would you rather have the money sooner or later? That could be the difference between a small to medium company going under or barely surviving until the High Court finally considers it. And it's also explaining to them the option of appeal is also a cost issue and something that delays enforcement further. So when parties litigate, they could only receive the money that they want after spending millions in legal fees, sometime 6 to 7 years down the line. But if one arbitrates, you can get to a solution and a decision a lot sooner, even with the review process. And if the parties agree to it, a possible appeal process, you will probably come to a conclusion a lot sooner. So it's, do you want your money earlier, or do you want to enforce the agreement earlier? And that's real benefit.
Thank you very much. Tumelo Bokaba has given us a question as well, and I think it's a very good question in the sense that we're all young practitioners sitting around this virtual table. And Mitchell, I'm going to pose this one to you. How does one build a career in arbitration and mediation? Is it recommended for a person to be an admitted attorney before pursuing a career in arbitration? I'm assuming that Tumelo then wants to go on to say, well, how do they eventually aim to become an arbitrator?
Thank you, Tumelo. And fantastic question. I think that it's about taking deliberate steps. Okay. So in terms of deliberate steps, this, for example, is one such deliberate step. Attending events, webinars, trainings, whereby that extent of expertise you can begin to learn about it. That's on the one hand. On the other hand, is that if, for example, you're already if you're seeking to eventually become a practitioner, so I suspect you maybe are not yet done with your qualifications, etc. There's a lot that can be done even before you become an admitted attorney, such as to build that. So, for example, if one is in university, there are ADR clubs and the things. There are opportunities to write, such that you come into the radar of those who practice in that area. One can seek internships even at that point before becoming an admitted attorney, whereby you begin to build your network, you begin to build links, such that when you then become an admitted attorney, you can then get the opportunities in the right law firms where this work is done as counsel. Now, if you're not even in the law space at all, right, it's just then about building expertise in the area that you are. So, for example, say you're an accountant, right, and you build that expertise, you can become a valuation expert when you're dealing with arbitrations and the like. Okay, so I think it's about being deliberate, identifying trainings, doing those trainings, because oftentimes people who know their stuff and who are just pretenders to the work. That's what I would say. Thank you.
Wonderful. Thank you very much. Valerie, this one is for you. And it's a vital question in the sense that it must be something that a lot of people think about. How is the independence, well, this is from an anonymous attendee, may I just first of all introduce the person who asked the question. How is the independence and impartiality of the arbitrator affected in handling disputes where there are large or controlling players involved? Is it common that arbitrators are not keen to handle such disputes or render awards against them for fear of loss of possible future business opportunities?
It's a great question, and really, independence and impartiality is truly the bedrock of a neutral. You need to be impartial and independent. So even when a dispute is brought before you, you need to weigh yourself. You are allowed to recuse yourself or to refuse to take up an arbitration if you feel that you will not exercise your independence in the way that you're expected as an arbitrator. But this is something, as you are trying to venture into arbitration, you need to be aware of these issues arise. They do not arise only once. They will arise at different points in your career where these situations come to you. So you need to know and bear this in mind as an upcoming arbitrator, that these issues arise. So you need to weigh yourself. You're allowed. It is truly allowed. And another aspect to it is repeat appointments by the same entity that borders on independence and impartiality. So if company X is always fond of appointing you, that should raise a red flag. This is something that you need to consider. So it borders on impartiality and independence. And there's so many circumstances, not just relating to a big short company. So many situations that can render your impartiality and independence questionable. So you need to bear in mind these issues, and you need to ask yourself, should I truly do this? But if it's for the sake of the purse, then you should also examine your own values, because arbitration is truly not just about the big shots, but even the medium shots and the small shots. It cutters across all businesses, and you should be able to determine an arbitration, a dispute in an arbitration, when it is brought to you without consideration of those. Obviously, you need to be paid well for the kind of dispute that you are handling. Bigger disputes attract bigger monies, and also they require proper skills to handle that arbitration. So even as you are building your skills for you to attract bigger appointments, you need to ensure that your skills are up to what is expected of someone who handle a technical matter. Thank you, Stephen.
Wonderful. Thank you very much. I'm going to bring up one last question, and of course, I'm going to put this one to you. Seeing as though we are overstaying our welcome to some extent, I suppose. But for disputes that, a question from another anonymous attendee, for disputes that involve parties that are not part of the arbitration agreement, does this factor disadvantage or reduce the possibility of a smooth arbitration? If it is a disadvantage, how best can this be avoided or settled? I think they're more going towards the fact that where you've got a party that's outside of the whole scenario. Does that influence how the arbitration is going to proceed, whether it will proceed smoothly or not?
It will. So if that party needs to be part of the litigation because they have some material interest, it could slow things down and may result in the parties having to approach the High Court rather. If I may use construction as an example, what oftentimes takes place is there's the main two parties, contractor and the principal. And contractor contracts with the principal, and they have an arbitration clause. Now, the subcontractor doesn't have an arbitration clause with his contractor, and the subcontractor doesn't have an arbitration clause with the principal. And if they do need something out of that subcontractor, that becomes an issue. But what one may do is, in creating your agreements, you include that all subcontractors would be bound as well, and you make that an enforceable part of every other agreement. And those subcontractors will naturally be provided with that. If I may just for a second go back to the previous question posed to me, I realize that the party that I was referring to being the principal is generally not the party that's struggling to include a arbitration clause. Now, if one were to want to include an arbitration clause, but the principal doesn't want to, the other issues, let's say within construction again, you're constructing some aspect which takes technical skills that only you or one or two other companies have, and the company on the other end wants it done as soon as possible. That's something that you have to bring to the other side's attention. There is the possibility that a dispute may arise where you want us to perform and you want the performance to be done sooner rather than later. That's an advantage that you want and that's an advantage we can only receive by having an arbitration clause included in our agreement. So the real issue is ensuring that the parties are aware of all types of disputes that may arise and the expeditious nature of arbitration itself.
Wonderful. Thank you very much. Last question, Mitchell, I'm going to pose to you. Seeing as though we have out of time just about. Anonymous has asked if the parties appoint an institution such as the Engineering Council of South Africa or the equivalent professional body in Nigeria to appoint an arbitrator, and that institution then rejects that nomination, rejects, I'm not going to appoint anybody. What do the parties do?
Thank you. So in that instance, it's a very interesting one. Oftentimes you may then have to go to court and ask the court to either do one of two things. The court may compel that institution if the reasons given for not appointing were, I can't think of one such reason, right? But if maybe it was discriminatory, if they just don't like this company, etc., and if it's in the ordinary course of business of this institution to do, the court may then compel. But what's most likely is that you may then ask the court to basically exercise that function of appointing, and the court may so do. But I should throw in some nuance to say that it also depends on the reason why the institution has chosen not to appoint. They may have chosen not to appoint because they've already seen that the substance of that matter is non-arbitrable, and for them, they would rather not waste their time. Okay, in which case, maybe it's to then look at whether or not that's even a matter that should be before arbitration and or should be before the courts. So it would depend on the reason why. But if it's for, a general, maybe random reason, then the approaches I said should apply. Yeah.
Wonderful, thank you. I think that's a nice point to end on. You know, we've been talking about arbitration being an alternative form of dispute resolution, and now that it's gaining more mainstream traction and whatever, but it is always going to be, how do I say, I don't want to use the word underneath, but it's always going to be subject to ultimately the courts in that particular country. You're going to have the courts being the ultimate backstop. If something goes wrong in the arbitration process, well, don't worry, you've got a judge as your backstop. That doesn't mean that arbitration isn't worth it. It doesn't mean that it is certainly not a good idea to pursue it. In fact, I think we're all in agreement here that it is. But even if it doesn't work, the courts are always going to be there to help us out as well. I would like to say an enormous thank you to you, Mitchell, Valerie, and Khotso. Thank you very, very much for all of your time. I realize that we have pushed the limits here a little bit in the timing perspective. On behalf of Young AFSA and our audience members, thank you very, very much. I do appreciate all of your contributions, and I've certainly learned a great deal from today's session. I do hope that we will be able to call on you in future for some future educational opportunities for our audience. And to our audience as well, a great big thank you for attending. I understand that the recordings of the session will be made available at some point on the Young AFSA website. And thank you very much for attending. A very good night from me.